All right, I've got a number of motions filed on behalf of Mr. Bryan. Take them in the order that I have them in my stack. The first one I have is a motion to prohibit any further conduct that may intimidate or influence jurors or otherwise interfere with a fair trial. It's filed today. Mr. Goff.
Your Honor, the motion sets forth the legal authorities and the factual basis for the motion in greater detail and specificity than was brought to the court's attention earlier this week. Looking back over the case, it seems that during jury selection, not as many matters were brought to the court's attention as I had assumed. But those have now been brought to the court's attention by way of the exhibits attached to the motion. Your Honor, we are concerned about individuals consciously or unconsciously using the public gallery of the courtroom to influence jurors in this case, whether that's influence them, intimidate them, whatever. We've had instances during the jury selection process of nonverbal communications back and forth between the victim's family and one or more jurors. We've had several instances of outbursts in the courtroom. We've had notable people in the courtroom who have no apparent connection to the victim's family in this case. We do have a jury assembly room which seats ample numbers of people. I think the Supreme Court precedent makes, although it's technically an open question, all the justices that have commented on it have either outright rejected the idea that individual members of the public have First Amendment rights in the public gallery, or suggested that it is intuitively not obvious that they have such rights. If the Arbery family has a minister or ministers that are their pastors or members of their church or otherwise, that's one thing. But just trotting in pastor after pastor after pastor, including pastors from other parts of the country that they have no apparent ministerial relationship with, is inappropriate here. And there's no reason, given the high-profile nature of this case and all the other unusual activities, protest marches and other things, there's just no reason to take that risk. We also have asked the court previously, and renewed that by written motion, is to identify the individuals who are sitting in the public gallery during the proceedings in this case. Otherwise, Your Honor, we, and I speak for Mr. Bryan, and whether co-counsel feel constrained to join in or not, that's for them to decide. But from Mr. Bryan's perspective, we're trying to make a record here. I'm not trying to be difficult or make anyone uncomfortable, but we can't have a record take up on appeal with respect to the impact of what's going on in the gallery without having that documentation. And I think the case law, although it is a relatively, the body of case law in this area is limited, but from what's there, I think the case law also seems to indicate that the court can't simply wait until something happens. We can't wait for disaster to strike. That the court has a duty, to the extent it can do so, to head off issues with the public gallery before they create prejudice to the clients, before they necessitate a mistrial. And we're simply asking the court to be more proactive. My understanding, and it's referenced in the exhibit, I think it's the first exhibit from the Community First Planning Commission, I think that's what it is. They have a huge rally planned for Thursday. Hundreds of pastors from across the country are going to be here for that. That is not something that is in response to anything that took place in this courthouse or during this trial. It is clear from the website of the organization, which has stated in more than once that my client, along with others in this case, are quote-unquote murderers, and they seek justice for Ahmaud, for Mr. Arbery. They have exceeded the capacity, the pastors who belong to that group, and I have not identified them. There's 21 apparently, black pastors in the community. They have gone, in that Facebook page and their website, they've gone beyond merely ministering to members of their flocks, whether consciously or unconsciously. And I think that conduct is such in conjunction with the conduct of counsel, civil counsel for the Arbery family, Mr. Merritt and Mr. Crump, and in conjunction with the Transformative Justice Coalition and all these other groups, when you look at the big picture, I think that we are rightly concerned about the ability of Mr. Bryan to receive a fair trial if we keep bringing people in this courtroom for who have no other apparent purpose other than by their mere presence to attempt to influence the jury in the case. Your Honor, the exhibits, I think, clarify maybe in ways that weren't as clear during the jury selection process how all these different groups connect together and what their purposes are. Several of these groups are created specifically as a result of the death of Mr. Arbery. So again, we're asking the court to allow us to have a record that we can take up on appeal and ask the court to take proactive measures to ensure that the presence of people in the gallery isn't violating the rights of our clients. I am told, I do not know whether that's true, that some of the pastors are packing in the sense that they are bringing their lawyers with them. And apparently, I'm told, of course, you know what rumor and speculation and gossip are like in a small town, that there'll be motions coming to be filed with the court in advance of their appearance. But that doesn't change our position, which is Mr. Bryan's right to a fair trial is paramount. And since there are no First Amendment rights to have content in the public gallery, then there's no First Amendment consideration there weighing against it. It's not an issue of public right access to the courts or the court proceedings because they're on national TV and they aren't available on the big screen in the jury assembly room. And although this court has labeled me reprehensible or
you reprehensible. Let's be clear about that. It was not specific. I was talking about some comments that were made. So I checked to make sure because I want to make sure that I did not direct that at you personally. Those comments were the reason I felt that at that time I needed to address where the court was on things. So I just want to make sure that's clear.
It is. And to be fair, like I said last night, looking back over it, I don't think the Community First Planning Commission, that group of pastors, I don't know that we specifically addressed that with any of the jurors during jury selection. So maybe I assumed too much. I will say, judging by my phone being blown up in my emails, that certainly the general public has interpreted the words of the court in a different manner than perhaps you and I did.
Well, just to be clear, I've said over and over again to all counsel here that personal attacks are not an appropriate. The court is not an appropriate place for personal attacks. You can comment on what's happening in the court, but do not direct it at anyone personally. So that's why I wanted to make sure it was clear that was not a personal attack on the court's behalf.
Thank you, Your Honor. From my perspective, I suspect I'll be continuing to get love letters and messages for days to come. But be that as it may, Your Honor, we are asking the court to take stronger steps to ensure the right of the defendants to a fair trial in advance of the events planned for this Thursday.
We join, Your Honor.
If I understand the motion, it is the remedy that's asked for is for the court to take note on the record in some way of who is in the gallery every day. If that is what this motion is, I don't see any harm in that, especially given the potential harm, as Mr. Sheffield said yesterday, the 2 strikes we've already had. Other than that, I don't adopt, other than that remedy that's being sought here.
Anything from the state?
No, Your Honor.
All right. The motion that is before the court, the written motion, has been addressed by the court on at least 2 occasions, and the court's indicated its position. I'm not going to replow that ground. The court's position on the record, when the motions are made verbally, remains the position of the court. I understand that this was to document the record to make sure that the court had the legal authority that was being relied upon, as well as some of the additional information here from the defendant. To the extent this is a renewed motion, a motion for reconsideration, or otherwise, the court's ruling is on the record.
Thank you, Your Honor.
I have a second plea in bar, speedy trial violation, and motion for reconsideration.
May I? I think everyone has a copy of that. I think I provided copies before. Your Honor, this is not simply a motion for reconsideration. Our contention is the court has to consider all the same factors anew. Since that was in June, we're now in November. We would like to add testimony, limited testimony, of Mr. Bryan on the speedy trial issue with respect to prejudice. And I don't know if the court wants Mr. Bryan to take the witness stand or whether he can testify from his place. That testimony would not be extensive.
Yeah, no, I can see him where he is. I think the court reporter can hear him. It's probably the easiest thing to do. And just to be very clear, the defendant's being sworn in for the limited purpose of addressing the prejudice prong under the speedy trial claim that was filed, ruled upon, and is now back before the court on a second plea in bar and motion for reconsideration, and we're not going outside any prejudice claimed under that claimed violation.
Yes, Your Honor.
All right. Everybody understand what we're doing?
Yes,
I'm
Judge.
looking at the state.
I know you are. Yes, Judge, I understand.
Have you spoken with your client about being sworn in and testifying?
I have, Your Honor. He's expecting it.
I'm not sure what that means. So have you spoken with your client about testifying before the court and some of the perils associated with doing so?
I have not explained to him that his testimony is under oath, but I believe at this point Mr. Bryan is aware of that.
Well, just take a
Subject to
moment.
prosecution for false statement or perjury.
And as I understand the limited purpose of what he's being sworn in for, what the potential perils of going beyond that limited purpose.
If Mr. Bryan were to go beyond talking about the conditions of his confinement, he could potentially open doors.
Okay, why don't you talk to your client real quick, just so I'm
Yes, Your Honor.
satisfied that that discussion has occurred.
Where are you, Your Honor?
All right. Mr. Bryan, understand? Swear to tell the truth, whole truth, and nothing but the truth.
Yes, sir.
All right, go ahead, have a seat.
And although it's more formal than normal, given that Mr. Bryan's going to be sitting, it may be easier for me to sit down. I don't want him to think I'm talking down at him.
That's fine. Just like to make sure you speak so the court reporter can hear you.
Yes, Your Honor. Mr. Bryan, where are you currently residing?
Glenn County Detention Center.
How long have you been there, sir?
I think about 18 months.
Would you describe your incarceration as oppressive?
I'm sorry?
Would you describe your incarceration as oppressive?
Yes, sir.
And by that, you mean no disrespect to the sheriff, do you?
No.
Can you describe for the court your daily routine over the past 18 months, approximately 18 months, 17 months, whatever it is?
Well, except, as you know, the last 3 weeks we've been here, but before that it's you get up at 5 o'clock, try to get your breakfast. You have a certain hour that you come out a day, so I'm locked down for 23 hours other than that.
Well, let's talk about that. Are you telling the court that you've basically been in lockdown or solitary confinement for the entire time you've been incarcerated?
For the most part, yes, sir.
And by that, you're telling the court that you spend 23 hours a day in an individual cell.
That's correct.
You don't have a bunkmate.
No, sir.
Okay. And could you describe briefly for the court that cell? it paneled? Is it sheet rock or is it cinder block?
No, sir, it's cinder block, probably about 8 by 12, something like that.
8 by 12, you think?
Yeah.
Okay. And the toilet that you use is stainless steel?
Correct.
All right. Are there any windows to the outside world in this room?
No, sir.
Okay. Are there any windows to your room at all?
The exterior room that I can see out to, there is a sun room, you know.
So there is a glass panel in the door of your cell?
Yeah, probably 6 inches wide, 36 inches tall, something like that.
And for 23 hours a day, the only daylight you can see is if you look out that window to see sunlight coming in a skylight in
Yep.
the big part of the building?
Yes, correct.
Do you have a television in your room?
No, not in my room.
Is there a television in your pod?
There is in the pod.
And how big a television is that?
30 inches, maybe.
And how far away is that from your door?
Probably 30 foot, 40 foot.
Do you have a remote for this television?
No, sir.
All right. So, do you have any other source of news or information other than watching that 30-inch TV from some distance away?
No.
All right. And when you have your meals, you indicated you have several meals a day?
Yes. Breakfast and at lunch we get a hot meal and then a bag dinner.
Now, are you going down to a cafeteria somewhere for those, or is that food being brought to you?
No, it comes to my room, to myself.
And that's for your own protection, am I correct?
Correct.
This solitary confinement, this lockdown, is not a result of disciplinary action by the sheriff. It's a reflection of the need to provide your personal safety.
Yes, sir.
Okay. Do you have a shower in your room?
No, sir.
Where's the shower?
It's, you know, at the bottom of the pod, community shower, I guess you want to call it.
All right. Can you take a shower whenever you feel like it?
No, sir.
How many showers a day are you allowed?
One in a 24-hour period. Well, I say that. That's what it's supposed to be. Sometimes it runs out to about close to 36 hours.
Now, is there a specific time, set time every day when you get to shower?
Not at all. No. It could be 8:30 in the morning, or it could be 4:30 a.m. in the morning.
I take it other people in your pod are also in protective custody,
Yes, sir. That's what that pod is.
which means that the people in protection can't fraternize with each other either. Am I correct?
No, sir.
So how many showers are there?
4 or 5.
Okay, but only one can be used at a time by
Yes.
by people in protective custody.
Correct.
All right. So the sheriff has to rotate everyone in protective custody to the showers one at a time through the day.
That's right.
And in order to be fair, the detention center rotates y'all through at different times of the day.
That's right.
So your shower might be at 3 o'clock in the morning.
Correct.
Okay. And during that hour that you're out, you can also walk about the common area?
That's right.
Okay. Now, since you've been detained at the Glenn County Detention Center, to be fair, you're technically detained, you're not incarcerated. Have there been some global pandemic come up,
Yes, sir.
sometimes called COVID-19?
COVID-19, Corona. Yes, sir.
How has that impacted your time in the detention center?
Thankfully, I mean, that I know of, we've had no outbreak per se in our pod. We have in the jail, and that has affected some of the staff, where they've had a good bit of rollover and things of that nature. As far as directly inside the pod, hasn't really affected me.
But it's been a fear.
Oh, yeah, most definitely.
And in fact, do you know whether at least one detention center officer died of COVID during the pandemic?
At least one, unfortunately.
Do you have any power as a pretrial detainee in protective custody to protect yourself against COVID-19?
No, there's not. They give us a mask.
All right. I believe, did you testify previously about your health conditions?
No, I haven't testified yet, I don't believe.
Okay. As we sit here today, you have no acute health concerns, am I correct?
Right now, the only concern would be my blood pressure, and it is managed right now.
All right. There have been times in the past when it was not managed as well.
Most definitely not managed as well. It probably just now got, probably in the last 8 weeks, 6 to 8 weeks, where it's managed.
All right. Let me ask you about visitation.
Okay.
Okay. As a pretrial detainee in protective custody, do you have any in-person visits with family, friends, ministers?
No.
Let me rephrase that. Do you know what a contact visit is?
Yes, I do.
Are you permitted, since you've been detained, or since COVID started last year, have you been permitted any contact visits with friends or family or your pastor?
Just my lawyer.
I take it that's me,
That's correct.
unless you're hiding somebody from me. Okay. Has it been difficult for you not to be able to have any physical contact with members of your family since your arrest?
Yes, most definitely.
And when they do visit, how many hours a week are they able to visit you?
On the monitor,
Well, on the monitor. First, let's tell the judge about the monitor.
well, when I first got there, I need to back up a little bit because I was in medical isolation and I'm not exactly sure why I was there because medical issues wasn't a factor at that point. But I stayed there for 3 months. At that point, I had non-contact visitation, which is through the glass.
Okay.
And
Like
then,
when you say glass, you're like old-fashioned glass, like a window
yeah,
with a telephone.
yeah, exactly.
Okay. All right, and then what happened?
Through about 3 months down the road, I got put in the pod, protective custody pod. So that caused visitations to go to the video monitor.
All right, so basically, you're seeing folks on a video that are at a remote location in the jail,
Correct.
and you get.
I don't leave the pod there in the visitation center.
Right. And how many hours a month can you do that? Or how many hours a week can you do that?
Twice a week, 15 minutes each.
All right. And other than your lawyer, that's basically the limit on your contact with the outside world,
Yes, sir, it is.
other than phone calls.
Phone calls, yeah.
Okay. As long as you pay for them, you can make all the calls you want.
Right.
All right. While you've been incarcerated, have there been issues with family and friends?
Yes, there's always issue with family and friends, so it hasn't stopped. Yeah.
Has it been difficult for you being detained all this time, not to be able to participate in their lives as they get sick or die or
Yes,
have
sir.
other life events?
Yes, sir, most definitely.
I have no further questions for Mr. Bryan.
Anything from the state?
No, Your Honor.
All right.
That is all the evidence we wish to present, Your Honor.
All right, record being closed. Any further argument on the motion for reconsideration? I was just going back over it, just to be clear. This motion for reconsideration, the court entered an order on June 15th, 2021, and at the time, that was a relatively lengthy order. Let's see. It's like a 6-page order, well, 5.5-page order. And in it specifically addressed the trial date scheduled for October 18th, which is the date that we began. And went through all of the factors. And again, the evidence that we just heard simply addresses the fourth factor, which is the prejudice. So that being where we are, Mr. Goff.
Your Honor, I'm not going to re-argue the Barker v. Wingo standards. I'm just going to suggest to the court that with the passage of additional time and the additional evidence presented with respect to hardship, the only real bone of contention I would have is the court seems to have limited the last factor, the prejudice factor, essentially to prejudice to the defense in court, which is certainly the most weighty consideration the court's required to consider. But I would humbly suggest to the court that the constitutional standard is broader than that. It doesn't matter. You can still have a speedy trial violation even if defendant's substantive rights at trial are not impacted simply by the length or hardness or other conditions of pretrial detention. I think that's clear from the precedents, and I would humbly suggest that your court did not give adequate consideration to such issues in its original order, and I would urge the court to perhaps address that issue, particularly with the additional evidence presented in what I presume will be a subsequent written order on the second plea and bar.
Anything from the state?
Your Honor, this is a motion for reconsideration of your order. There's nothing new here for the reconsideration. We've heard about the conditions at the jail, which are what everyone's experiencing out at the Glenn County Jail. There is nothing new here, and his ability to prepare his case has not been impaired in any way. He has contact visits with his lawyer, access to a telephone to talk as much as he wants, 2 times a week, 15-minute video conferences. So at this point in time, none of this criteria takes us out of the Barker v. Wingo factors that were already decided. And there are numerous factors, and then the 3 parts for prejudice. And this is only one of the parts, and it's not even the part weighted heavily. So Mr. Goff has failed to, or Defendant Bryan has failed to bring anything to this court for your reconsideration. We ask that you deny the motion.
All right. The court's considered, or I've read through the second plea and bar. First, the court notes that, technically it's untimely. It's outside the term of court upon which the original order was entered. So as a motion for reconsideration, it would be untimely. That's State v. Ross, 293 Georgia, 834 was actually a plea and bar case. But beyond that, the second plea and bar raises no additional issues. The first order, first motion, was addressed through an order which specifically addressed the court date that was the beginning date for this trial, October 18th, 2021. We do have some additional information with regard to the 4th prong. The court's already addressed all of the other prongs and exactly how we got there, and having considered the evidence presented here today, finds that there is not sufficient prejudice to the accused under the 4th prong in order to grant the plea and bar. So that will be the order of the court. The final motion I have is the motion for reconsideration of the special demur as to count 7 and the alternative requested jury charge and special verdict form for count 7 of the indictment. Mr. Goff.
Your Honor, my first inquiry is I may have electronically filed it. I don't know if the McMichael defendants or the state have copies of it. I have extra copies, so if there's any doubt, I just assume provide them. Your Honor, I'm pleased that the court has allowed us to address the motion for reconsideration on the special demur as to count 7, which also has requested jury charge and special verdict form attached. I'm guessing that this motion for reconsideration is not in the same term of court in which the original order was entered. So I have an abundance of caution. I'll orally modify that as a second special demur. Special demurs can be filed even during the trial, so it's certainly timely. Your Honor, I do think with the motions for directed verdict coming in the morning, this is an excellent time to address this issue because it relates to count 7. And Your Honor, I'm not going to reread all the paragraphs of that motion, but it seems pretty clear that, notwithstanding the authority cited by the court previously, that the way the state has charged count 7, alleging assault with one and or both pickup trucks and with 3 different defendants, either as parties to the crime or as principals, when the indictment doesn't specify how it's being, it's not just a matter of providing notice as to the nature of the weapon. In this case, and it's a constitutional issue, Your Honor, which can't be sidestepped by cases that are factually and legally in terms of the charges different. In this case, the state is alleging potentially a dozen different aggravated assault counts in one without telling the defendants exactly what they're defending against. We also have 2 different competing theories here, which will be important in the morning. Is the state contending that Mr. Bryan intended to strike Mr. Arbery with his vehicle? Or is the state contending that Mr. Arbery was reasonably in fear of receiving a violent injury? I mean, those are 2 different ways of charging aggravated assault that are kind of lumped together. Now, if the state is proceeding on an intent to injure theory, that Mr. Bryan was attempting to strike Mr. Arbery with his vehicle, then all kinds of lesser offenses come into play. If the state is contending that, not that Mr. Bryan was attempting to strike Mr. Arbery, but that whether he intended to do so or not, Mr. Arbery was reasonably placed in fear of receiving an injury, then that takes us right back to where we were a long time ago, that the state's fundamental contention that what's going through Mr. Arbery's mind is not relevant, that the only thing that's relevant here is what's in the minds of the defendants, that gives the lie to that position. Because if the state's proceeding here under an aggravated assault theory that's based not on the intent of the defendant, but on the understanding and the fears what's going through the mind of the victim, then that's a pretty important consideration. But in terms of how we charge this jury in this case, maybe I'm overthinking it, but there's so many different ways a jury could come back with a verdict of aggravated assault in this case, depending on what legal position you're coming from and what the factual basis is. How do we assure jury unanimity in this case? 6 jurors think one person's a principal, another person's a party to the crime. 6 jurors think that the assault took place with the McMichaels truck. 6 jurors think the assault took place with Mr. Michael's truck. Or 5 of each, and 2 think it was some combination of both. There's no way, as count 7 is presented to this court, I would respectfully submit, it's not a question, it's not a challenge to the court's legal or intellectual knowledge or skill. It is a fundamental truth here that there is no way to charge this jury with all the different ways this can happen and to assure that a jury verdict is going to be unanimous. There's so many different ways that this can be looked at that the defendants are not meaningfully on notice of what they're defending against. If they're convicted, I don't know how you're going to apply double jeopardy to it, and I don't know how you're going to have determine whether a verdict is unanimous. The state has basically created this kitchen sink count that subsumes multiple different legal theories, multiple different ways things can be done, and there's no way to sort it out. And I'm just suggesting that before we get to the directed verdict stage, which is problematic for the state on count 7, but I don't think we get there, because I think this court's obligation in this situation, now having heard all the evidence and had the benefit of a lot more information as to the charges, as opposed to where we were when the court first considered the question, where we are now, I believe that the court will reluctantly be constrained to agree that the demur as to count 7 needs to be granted.
Anything from the remaining defendants?
I'd like a chance to read it and consider it if I could, unless you're ready to rule on it.
I'm going to hear from the state. I'll be very candid. What I'm probably going to end up doing is taking it under advisement until tomorrow morning and addressing it at the same time as the directed verdicts. Or motions for directed verdicts, which I assume are coming. I don't want to presume for anybody, but I assume they're coming. From the state?
Yes, so first off, this is untimely. However, it's a motion for reconsideration of something you've already ruled on, and the state's position is that the language does track the statute, which is all that is required and is necessary. A demur basically means that they have no notice of what's going to happen. This appears to be, we have trouble with a verdict form. I've looked over the verdict form, which, Your Honor, and I don't want to presume, I'm assuming, and it's just an assumption on my part, that Defendant Bryan will have his own verdict form, that Defendant Travis McMichael will have his own verdict form, and that Greg McMichael will have his own verdict form. And the way, of course, Mr. Goff has proposed this, I don't believe is legal, because the defendants have been indicted as parties to the crime. And there is absolutely nothing, no law that supports a designation that the jury has to write, I'm finding him as guilty as the principal or as the party, or that he helped, and that's why I'm finding him a party to the crime. There's absolutely nothing that requires the jury to do that. They can find certain people acted as a party to a crime. They can find Greg McMichael guilty of this as a party to the crime, even though he didn't have his hands on the steering wheel at all. So that, of course, party to a crime argument is disingenuous, as is this verdict form, which...
As a motion or argument is being disingenuous here. I thought it was the state saying we shouldn't be jumping to conclusions or assuming the worst.
I'm sorry, I didn't mean to say Mr. Goff was being disingenuous. The argument itself that somehow a jury has to designate a principal or party or some sort of designation is not what the law is. And so therefore arguing that without any supporting case law, it's unsupported. In addition, all of the jury charges that Mr. Goff has put on here are not the pattern current jury charges. So the argument does not even follow the law as it is right now with the pattern jury charges from the Superior Court Council. So given all of those things, we ask that the special demur be denied based on what we argued before and the untimeliness and the fact that the requirements that the defendant is asking for are unsupported by the law.
All right. Any final word then, Mr. Goff?
Your Honor, the requirement that a jury verdict be unanimous, that's never untimely. And that's a huge issue here. The fact that defendants are entitled to a fair trial, that's always an issue here. And I would be shocked if the court would proceed to present things to a jury that would otherwise be inappropriate on the state's theory that somehow it's untimely. There are special demur issues that can be untimely, but constitutional problems in the presentation of the case to a jury cannot be avoided. And I'm not the one who drafted the indictment. That was the district attorney's office that did that. I'm not even sure that was Ms. Donoghue, but her office did it. And here we are. And again, and that's the point I would ask the court to ponder overnight, how do we ensure a unanimous verdict given all the different directions the state can take? And is the court really comfortable with the idea that the state, who gets the last word in the last portion of their closing statement, gets to tell defendants and defense counsel for the first time, after there's no opportunity to present evidence and no opportunity to argue, what their actual theory of aggravated assault is going to be? Because I think what we do know, having listened to the opening statement made by Ms. Donoghue, that whatever theory of aggravated assault they have, it can't be the one they presented to the jury in their opening statement, because that one's just not going to fly. So whatever other theory, whatever their real theory is, if they have one, we're certainly entitled to know what it is before they get up at the end of the case with the last word.
All right. As I indicated, I'm going to take the matter under advisement, and we'll go ahead and address that in the morning. What I am hoping to do tomorrow morning is convene at 9 o'clock for any motions properly presented to the court based upon the state resting its case in chief. And be ready, it sounds like, at least some of the announcements were, I'm cautiously optimistic that we will be ready at 10 o'clock then, Mr. Goff, for your opening statement, and then plan to get into the evidence right after Mr. Goff's opening. Well, no, let me back up. Directed verdicts. Also get on the record what the defendants' positions are with regard to testifying, whether they've been informed by counsel of their rights and understand their rights. And then get into Mr. Goff's opening statement and then any evidence that would be presented. Anything from the state?
No, Judge, not this time.
From Travis McMichael.
No, Your Honor.
Greg McMichael.
No, Your Honor.
From Mr. Bryan.
No, Your Honor.
All right. We are in recess then until 9 o'clock tomorrow morning. Thank you.